Now, another big story we're following today. Fewer jury trials could take place as part of proposed reforms to prevent a total system collapse of the UK's courts. It's one of the recommendations put forward by Sir Brian Leveson, chairman of the Independent Review of Criminal Courts, in a bid to tackle a record-high backlog of cases. Well, Sir Brian Leveson, I'm pleased to say, joins me now. Some extraordinary numbers, Sir Brian, when we talk about what's going on in the courts. Almost 77,000 cases waiting for trial in court. That's rocketed up in the last 2 years alone. Why is this happening? Why is there such a backlog?
Well, the backlog is a consequence of a number of features of the system. The first is that it is the consequence of chronic underfunding of justice for many years. The Ministry of Justice was not a protected department, and as a result, courts and lawyers have suffered dramatic cuts, which has meant that fewer cases have been able to come to court. In the period between 2016 and 2019, there was a reduction of the cases going into the court, and therefore courts were shut and money was restricted. But with the increased number of police officers, so there has been an increased number of cases come to court, which has added to the backlog with which we can't cope. And even though everybody is striving very hard to do what they can to deal with the backlog, the fact is that between December and March recently, the backlog has increased by over 2,500 cases. So unless drastic action is taken, the backlog will carry on going up. That's the first, the money. The second is that cases have become much more complex. When I started the bar in the early 70s, I could certainly do 2 small trials in a day and maybe even start a third. Now every trial takes a day and a half. It's just much longer. Why? Well, in part because of the protections we've properly provided to defendants, the Police and Criminal Evidence Act, disclosure of unused material, protections for vulnerable witnesses, special measures, live links, increases in the way in which we deal with evidence, but also the technology has changed the way in which we operate our courts. So the mobile phone, which was not a device that was available 20, 30 years ago, is now the go-to source of a great deal of evidence about movement of those accused of crime. That's also increased the length of trials. Finally, there's COVID and the industrial action by the bar, which added to the backlog and has left it such that it is unsustainable and incapable of being brought down without really radical measures. So
it's seemingly immovable issues that you're presenting us with in terms of the problem at hand. But you are talking about radical steps, including when court resolution isn't appropriate. So what are those offences and what really is the alternative to a court hearing?
Well, a large number of cases don't need to go through the court system. If somebody, for example, is arrested for a minor offence without previous convictions, it might be entirely appropriate to offer an out-of-court resolution to that case, which might mean a penalty notice, it might mean a bit of unpaid work, it might mean some community rehabilitation. But there are mechanisms out of court to allow resolution of cases. Of course, those who are then being offered that alternative need legal advice to decide whether to take it or to want to go to court and face a trial. So that's the first measure, whether cases need to go to court. Then there is the question of what cases deserve and require the full panoply of a Crown Court trial. I have spent many years and have the greatest respect for juries. but the question does arise whether some less serious offences justify a Crown Court trial at very great public expense. Money has not been the driver of my recommendations. I've considered proportionality, fairness, timeliness. All these features are relevant to the determination of a fair trial. The touchstone, however, has been to acquire a fair trial for all, for witnesses, for victims, for defendants.
And so, Brian, there are a lot of changes that you are trying to address. You're talking about radical steps. What are you hoping will happen? Because presumably you've worked on this report, and as you've said, it's extraordinary what's happening now in the judicial system since you first started. What are you hoping for?
Well, I'm hoping that people will recognise that what is required is a wholesale reform of the system. The recommendations I've made are not intended to be a pick and mix, choose this or choose that. They are much more a system change, because without a system change, I fear the collapse of what we know as the delivery of criminal justice in this country. If a trial is being listed, as some are in London at the moment, for 2029, that's a denial of justice. It's a denial of justice for victims, for witnesses, and even for defendants who have the case hanging over their heads, who might even be acquitted and have had to cope for years with their lives on hold. None of this is satisfactory, and unless we address it, the situation is going to get worse, and the public confidence in our ability to deliver justice will suffer accordingly.
So, Brian Leveson, thanks very much indeed for joining us on Sky News.
You're very welcome.